Mr. Jones, do you have a spare copy of your speaking notes?
Many copies, maybe.
And the reason I asked that is I left mine because I'd taken it up over the short adjournment. And rather than send for it, I've got the schedule. It's the speaking note,
Perfect,
please.
Thank you.
Thank you. It's very helpful. It's really good. Thank you.
Very much. I've been guided by your suggestion before lunch that I focus in over the lunch and adjournment on a few remaining key points. I hope in having done so I don't miss something that you've yourself identified as actually quite key. But what I propose to do is then to focus on three remaining elements of the speaking note, if I may, and to take you first, therefore, to page 19. You'll be reading to here, getting even closer to the end than we were before. And page 19, under the heading Reassessment of Private Life, and in particular strong features. This is second half of that page, beginning paragraph 119 of the speaking note.
Thank you.
And just preempt what I'm about to say, the observation that recalling what it was that the upper tribunal was, we say, principally focused on doing, which was to re-evaluate private life in this case. Its conclusions on this aspect of the evidence are especially critical, particularly as they go on to direct themselves within the determination that is principally in reliance upon what they reason in this regard as to why they reject the application of the refusal exception. So if we could turn up the reconsideration decision,
Yes.
and in particular if we could go first of all to paragraph 42.
Can you give me the page number?
Of course, maybe, I beg your pardon.
No, not at all.
Page 37.
Thank you.
So there are three aspects of the determination we're going to look at which describe the way in which the upper tribunal approached private life, and we say unlawfully and irrationally, attaching inappropriate weight to the appellant's offending and criminal history.
Right.
So we could look at first passage, paragraph 42. It's actually the second aspect of that paragraph, beginning, however, the private life developed.
Yeah.
So the tribunal says, however, the private life developed by the appellant was weakened by his criminal offending and flouting of punishment from the age of 14. This behaviour continued and escalated, notwithstanding the positive family and other relationships in his life. The appellant may have concluded his education, primary education and secondary education in the UK, but Mr. Jones does not draw our attention to any secondary education qualifications he achieved. It tends to indicate the appellant did not achieve any worthy of note that would be consistent with the appellant's history of juvenile offending. And we'll come back to that finding when we look at the facts very briefly in a moment. But if we step on from that finding then, whilst we're in this document, to paragraph 47, which is at page 38. And it's the first aspect of that paragraph we're concerned with. The tribunal continues in the same theme. Whilst we accept the appellant is clearly socially and culturally integrated in the UK, the nature of his links to the community have not been entirely positive. He began offending and associating with pro-criminal individuals at the young age of 14. The appellant continued to offend during his teenage years. Although he came to the UK at a young age, the strength of his positive connections and social ties have been weakened by his criminal associations from a young age. He demonstrated a disdain for the rule of law and the punishments handed down to him. His offending carried on into his adulthood, and he committed a very serious offence when he was 21. And then finally, if we go over to paragraph 48, it's the last few lines of that paragraph on page 39. Beginning, we are satisfied. Last 5 lines. We are satisfied the appellant's length of residence, which began when he was a child, together with his upbringing, education and family relationships, are such that he has been and remains socially and culturally integrated in the UK. However, his history of offending and lengthy imprisonment have weakened his integrative links and the overall strength of his private life. Now, we take issue with that approach in two ways. The first is that we say the approach of the tribunal is inconsistent with the way that this court has encouraged the evaluation of private life in the context of a person presenting with a history of offending. And to that end, if we could turn up in the authorities bundle the decision in CI Nigeria, which is at tab 16, and turn to page 388, paragraph 60. And I do recognise, first of all, that obviously the comments, the findings that are recorded by the Court of Appeal in this case are focused upon the establishment of cultural and social integration for the purposes of section 117C4, which the tribunal rightly has identified is settled. But we submit that the approach to the evaluation of private life ties in the context of offending that's articulated in this judgment are as material to the exercise that the upper tribunal is performing here as they are to an evaluation of that, the satisfaction of that exception. So if we could, I'm afraid it's necessary to spend a little bit of time on this authority. If we could go then to paragraph 60 first of all, which is page 388.
Where are we in your speaking note now?
My Lord, we are at paragraph 123 of the speaking note.
Okay. Yes, thank you.
Maybe I can direct you to the relevant paragraphs and just invite you to read them for yourselves, or I can...
We can read it. My Lord's inquiry there is very, very upside, because in 123 of your speaking note, you refer to paragraph 75, 76, and we've got to include paragraph 60.
Lady, I'm just stepping back a little bit to give the context.
I see.
If the court will permit me to do so.
Yeah, of course, yeah. So, but we can read that. You want us to read paragraph 60 to...
and then if you could step from there to paragraph 62, Lady.
Yeah, okay.
But it's a relative point that's being made, isn't it, in 62 and in the Claim Office Guidelines, and the upper tribunal used the term weakened, it's not destroyed side. So is it necessarily inconsistent?
I accept what your Lordship says, absolutely. But to the extent to which the tribunal have relied upon the mere fact of offending and the implication of offending over time in order to infer a breakdown in private life ties and connections is inconsistent with what CI is saying.
They didn't say breakdown, it referred to weakening.
A weakening, my Lord. I apologise. The language, your Lordship's language is absolutely right. But my Lord, even that is impermissible. What CI is saying is you must look at the individual facts of the case and identify, by reference to those facts, actual implications with regard to a breakdown in ties and connections and relationships. They continue the theme. If we could step on to paragraph 73, they give an example, a scenario, by reference to the case of AM Somalia, where precisely that happened.
Yes, in Somalia, on the facts there, the court found that it was not integrated. There might be some cases where you're fully integrated. There may be some cases where you are not very integrated, or
it may be weakened, as you say. I agree with your lordship, but it's the indications that are critical. Because what's being identified in AA in Somalia is that it is not the fact of offending that's critical, it's the consequences of offending that are critical. And what the tribunal in this instance is doing is focusing on the fact of offending, but identifying no consequences. Where in their determination do they identify a tangible consequence as a result of the appellant's offending history with regard to a breakdown in his ties to the UK? And they do not. They assume that that is what's happened, but they don't identify it. And as I'll show you in a moment, all of the actual indications with regard to evidence are contrary to the assumption that they're making. Before we do that, if we could just, I apologise for labouring the matter, but if the court would mind reading paragraphs 75 and 76 of CI also, and then finally 78 to 80. I'm picking.
When my lord's finished reading, I want to ask a question about it, if I may. It seems to me that there's a slight confusion of concepts here, isn't there? In that what CI India, CI is considering is whether or not the social integration has been lost, which is specifically in relation to the test for exception 1. And that doesn't arise particularly, does it, in our case, because they found in 48 that he did remain socially and culturally integrated. What they then went on to say is that he weakened his integrative links and overall strength of his private life, which isn't a question which was being considered at all in CI.
Well, I appreciate that the specific test with which the court was concerned is the 117C or B test. But as I took the court earlier to an earlier aspect of CI where it defined the parameters of private life, which is paragraph 57 and 58. It's clear that the court has identified the evaluation of that issue obligates a broad consideration of private life issues generally by reference to established jurisprudence. So it's not in any way narrowed down or confined to specific issues of social, cultural integration. It's everything. And so the exercise, that's why we said in our earlier submissions how significant it is that the Secretary of State first and then the First Tier Tribunal accepted, and the First Tier Tribunal by a margin that the appellant was socially and culturally integrated. Why that was significant to the overall evaluation, because we say that took him over the line on the Rupia exception. But for the purpose of this evaluation, we say everything that's said in CI Nigeria is as opposite to an evaluation of broad private life issues, in particular with regard to the bearing of criminal offending on the evaluation of those issues. So I completely understand what your Lordship is saying. You're right that the language of CI is very much focused on, in the latter parts, on the satisfaction of that exception, because that's what the court was concerned with. But in terms of what it was doing, having identified the parameters of that provision, it was essentially exactly the same exercise that the upper tribunal purported to be performing. And what the upper tribunal actually did was, having identified social and cultural integration to a material extent, has gone beyond that and resiled from that conclusion by clawing back by reference to offending history. And that is not a sustainable position for it to assume by reference to the analysis in CI. But more critically, what CI ultimately is saying, apart from the element where it speaks about double counting and the impropriety of weighing in to the balancing, positive side of the balancing exercise, criminal offending. I'm not sure if you had that reference. It's paragraph 80.
The double counting is 79 and 80.
That is the language of the tribunal, in the upper tribunal, in particular at paragraph 47 that we read earlier, is very much emphasising it's a critique of the appellant's conduct. He used the language of his, just find it again, his disdain for the rule of law. They're factoring in an evaluation of his conduct into their assessment of private life. And that is precisely what CI says is not permissible. They're inferring that he is repudiating the values of the UK, the social contract that all citizens have with the UK by virtue of his conduct. And that is what is severing his private life ties. Because they don't anywhere identify an actual material consequence for his ties. What do we know from the findings of fact that are recorded? His ties to his extended family are as strong as ever. The upper tribunal make a point about the support that he obtained from his parents. His relationship with his wife was unaltered, and certainly was even stronger. It was unaltered by his imprisonment, and by 18 months of release was even stronger. His relationship with his son was accepted by everybody to be an extraordinary, strong character. He had evidence about continued social cohesion through friendships. He had offers of employment. And also during his imprisonment, on the findings recorded by the First Tier Tribunal judge with regard to rehabilitation, those two were critical to an evaluation of his private life, because what did he do when rehabilitating? He is engaged in community activities, sporting activities outside of the prison. He is supporting services within the prison. He is integrating and networking and socialising and educating throughout that 5-year process too. The tribunal is making assertions and drawing inferences without evidence. There is no tangible, material consequence to this man's social and family life ties, the fact of his offending history.
But if you read the last sentence of paragraph 61, CI, Lord Justice Leggett is making it clear that criminal offending and consequent imprisonment may affect whether a person is socially and culturally integrated.
It may not, I agree, but it hasn't.
It's a sliding scale. As my Lord said, this CI is an all or nothing case. That's why they...
But my Lord, it is a factual exercise to be evaluated. All of the facts are on one side of the scale. Where in the determination, apart from pointing to the fact that he's an offender, does the tribunal identify a practical consequence for his private life and family life ties?
He'd spent 5 years in prison for a start, and therefore his relationships with the outside world were rather curtailed.
They altered, my Lord, but they didn't. They didn't end. It was a different within the prison system.
But nobody's saying that. Is my Lord's point. They're not saying tribunals. My reading of it is that this was a factor which weakened it on the scale. No more, no less.
It was a factor which, by virtue of the language and in the absence of actual evidence, was not one that was permissible for them to weigh in the scale in the way that they did. Lord, there has to be substance to the assertions that are being made, to the findings that are being recorded, but where is the substance? This was a very unusual case, as the First Tier Tribunal concluded, where in terms of the strength of ties, family members in particular, they were unaltered by a protracted period of imprisonment. And where this young man transformed himself in the course of that imprisonment. And by the time he was...
I think we've got the point, and time's moving on.
I would just flag up, my lady and my lords, that when the Secretary of State recorded her conclusion about cultural and social integration, she did so in the context and full knowledge of all of the appellant's offending, including his index offence. And you'll find that reference in the supplementary bundle in the refusal letter. I'll just give you it very quickly.
We are here looking at the decision of the upper tribunal.
We are, my lady, but it's still material. The Secretary of State is the original arbiter of public interest. And she's saying, I've looked at...
Yeah, she's the original arbiter, but then it comes to the courts.
I'm not making a big point about it, my lady, but I simply draw it to
Well,
your attention.
you're wasting time on it, Mr. Jones, I think.
Very well,
If you've got two other points to make...
I have, my lady, and I'll
Yeah,
make them
we
now.
need to hear them.
So, my lady, my lords, first of all, we say that in the context of the rebalancing of public interest, the upper tribunal has gone wrong, because it is, to whatever extent, even if it is nominal, the extent to which it has undermined the appellant's private life ties by reference to the consideration of the mere fact of his offending, that is neither lawful nor factually sustainable. Turning on to the treatment of the... Just make sure I don't miss anything. Yes, the issue at page 21, if I may. Reassessment of family life exceptions. Now, and I think your Lordship, your Ladyship drew my attention, I think, to the fact that the upper tribunal concluded, in respect of the two family exceptions, that they were only just met in its estimation. And the references for that finding are page 34 of the core bundle, paragraph 33. It's a really lengthy paragraph. I can just locate the relevant aspect.
Just last line,
Yeah.
paragraph 33, and
Very good.
third line from the bottom.
I had the wrong page, I forgive me. And the second reference then is at page 35, paragraph 36. Sorry, the other way round. Page 35, paragraph 36. And it's the first.
Yes.
Now, it's important, first of all, to bear in mind that that is not a finding we submit that the First Tier Tribunal arrived at. And I can take you back to it, but you'll recall in the very compelling circumstance evaluation that the First Tier performed at the conclusion of its determination. And it was paragraph 140 at page 124. The First Tier Tribunal actually acknowledged that had his sentence been a bit lower, the implications, the undue harshness for the appellant's partner and his child could have carried the day. So, in his estimation, the very compelling circumstance test could have been met, but that the public interest side of the equation was weighted too highly. So that is not a finding that the unduly harsh test is just met. It is a finding that in a circumstance where there is a less weighty public interest weighed against him, that the very compelling circumstance test would have been satisfied. So, and if we look also at the upper tribunal's summary of the findings of the First Tier at paragraph 32 on page 34, this is the second sentence beginning ease mental health. This is where it's, as I said, summarising the FTT's detailed findings. It says ease mental health, her care for Y, and her career would all suffer, seriously suffer. The impact upon E and Y would be both more than would necessarily be involved for any child or partner whose parent or partner was faced with deportation, and more than that which is acceptable or justifiable even in the context of a high public interest engaged. The ISW report then goes on to summarise that. And this is...
It then goes on to say, our assessment has taken all of these matters into account.
That's certainly what they say, my lady, and they repeatedly say that they are weighing in what the First Tier Tribunal has concluded.
Well, why should we disbelieve them?
Because, my lady, what they describe here as being the retained findings of the First Tier Tribunal are no way consistent with their judgment that the unduly harsh threshold for the appellant...
That's not right. Our assessment has taken all of these matters into account. We accept that exception 2 is met as at the date of the hearing before us. We now turn to consider whether there's evidence to support the claim that the disruption to family life goes over and above the level of undue harshness. We're obliged to consider this for section 117C6, and we do so now. I mean, that's unassailable, isn't it? They have got to consider it.
It's unassailable in terms of a statement of law, lady. It is entirely assailable in terms of the perversity of the conclusion that they subsequently reach. Where is the evidence to enable them to come to a different conclusion to the First Tier Tribunal? By the time this matter got to the upper tribunal, all that had happened in terms of the ties that the appellant enjoyed with his family is that they had become stronger. The upper tribunal itself requested an updated independent social work report, and the content of that independent social work...
Whatever the independent social work report contained, and even accepting the fact that upon his return to family life, the strength of the union was increased, that doesn't trump 117C6. It's for the tribunal to determine whether or not that then comprises compelling reasons over and above exceptions 1 and 2.
I accept that, my lady, completely. But what they have to do is perform that evaluation in the context of a rational framework of findings of fact. And their finding that those unduly harsh thresholds are just met is not a rational or sustainable finding.
Well, in paragraph 32, they don't say just met, actually, do they?
Well, no,
they
go on to
through
say it twice.
all of the things that the First Tier Tribunal have found. They refer to the Independent Social Workers Report of October 2019, which supports the analysis of the FTT, describes the relationship between the appellant and Y as becoming even closer since cohabitation. And it goes on to say, we have taken these matters into account. And you're asking us to say, well, ignore that particular sentence in the paragraph.
I'm asking you to say, look for the justification for resolving away from the clear findings that were made in the First Tier Tribunal, which are retained findings.
Well, the judgment does go on to say why. They come to the conclusion that, bearing in mind all of these things, on the assessment of the upper tribunal, this is not sufficient to reach the very high standard that's required.
So what they have done, my lady, is impermissibly substitute their
No, they
opinion.
haven't. What they've done is not impermissible. They have not gone behind the facts. They have weighed the facts. And since they are remaking the decision, they're not altering the findings of fact. They're saying, but the weight that was given was insufficient.
But that too was impermissible with respect, lady. Because
Why?
in the error of law decision, as you'll recall, paragraph 59, if I get the right paragraph, what was agreed as the basis of approach, page 93, was not just that the facts would be retained, but the evaluative exercise performed by the First Tier Tribunal would be retained. Unless the only basis upon which it should be interfered with is if the circumstances had changed to enable the redeploying of a different set of findings. This wasn't just, is it settled that the appellant is in a relationship with his wife? It was the evaluation of all of that evidence by the First Tier is retained findings. So if the upper tribunal is going to go behind the clear findings of the first...
Well, they haven't. They say that they preserve the factual findings. Where do you say that they refer to the fact that they're going to retain the evaluation of them?
Lady, paragraph 59 of the error of law hearing at page 93. It says, in addition...
To be fair, they refer to factual evaluation.
But this is a factual evaluation, my lord. All of these...
Not an overall evaluation.
But, my lord, it's an evaluation of the facts against a set of criteria. And the criteria, as we established at the beginning of this process, are not in issue in terms of what is relevant to that exercise. The facts should not have been in issue either, but they were put in issue, effectively, by the reconstruction of the re-evaluation of unduly harshness. And this is what the upper tribunal repeatedly does. It says it's retaining the findings of the First Tier Tribunal, but then subtly goes behind them and records a different position, either in the public interest context, elevating that side of the threshold, or in the family life and private life context, gradually undermining it.
Okay, well, I'm going to move you on, but because you've already gone over your half hour.
I apologise, my lady, but I'll endeavour to get through the rest of this promptly, but just to return very briefly to that point.
No, we're not returning to points, Mr. Jones. You've either got to move on or concede that we'll regard your written submissions for your submissions.
I'm absolutely content for you to do that, lady. I just ask you to do this, if I may. This finding that the unduly harsh thresholds for the in this context, in respect of this child, this British child, and this British woman, are only just met, are not sustainable. They are irrational. This, on the findings of fact and on the expert evidence which was not repudiated.
You've made that point 3 times already. I think we've got it. Thank you.
You have the schedule that I prepared, which describes all of the findings recorded by the First Tier Tribunal. The child Y has been damaged emotionally and developmentally as a consequence of what he's already experienced. The predictions are that he will suffer more damage going forward if there is a repetition of separation. And indeed, on the independent social work evidence that was before the upper tribunal, the prediction in fact was that it will be even worse now than it was originally apprehended to be. In respect of the appellant's spouse, the predictions of harm are established too on the evidence and on the First Tier Tribunal's findings, and harm has already been effected against...
Yeah, we're looking at the upper tribunal's decision. We're not making the decision ourselves.
No,
that's
lady,
the difference. And as Mr. Malik says, we've got to be very, very careful that this appeal concentrates on errors of law.
It does, my lady, but this is an error of law. If the upper tribunal is recording findings of fact which cannot be sustained by the evidence, that is perverse. It is irrational.
Where do you say that the finding of fact is recorded that's perverse?
Well, the finding of fact that's recorded that the unduly harsh thresholds are only just met is a perverse finding.
But that's not a finding of fact. That's an evaluation of the evidence before it. So where do you say that there's a perverse finding of fact on the evidence?
It's irrational then, my lady, for them to conclude that that threshold is only just passed on the particular facts of this case, which were recorded by the First Tier, retained by the upper tribunal, and consolidated by further evidence in that jurisdiction. And, my lady, as is addressed in the skeleton argument, we rely too on the decision of this court in HA Iraq as to the actual proper approach to the evaluation of undue harshness. And I've cited the relevant aspects of that judgment in the speaking note, in particular paragraph 141. I can take you to them, but if you're content to refer yourself to them and to acknowledge the submission I'm making on their own, I'm quite prepared to move on. The underlying submission we make in respect of that is that the bar for establishing undue harshness has been moved as a consequence of the evaluation in HA Iraq into a recognition, although it's ultimately factually sensitive, the recognition that even particularly strong attachment between a child and its parent is capable of crossing that threshold without more, even without the actual consequences of emotional harm, which they have in this case. And I commend also to you the findings of Lord Justice Jackson in HA, this is at paragraph 146, subparagraph A of the speaking note, where he equates emotional harm with physical harm. There is no basis for disparity between the two in terms of the weight to be given to it. So we say that on the proper legal approach within that framework, formed against the facts as they are controversially described in the termination of the First Tier Tribunal, in particular in this ISW's report updating, that it was irrational to conclude that the undue harsh test was only just met. I'll just have a moment. There was a third point I just wanted to clarify. We could just go to page 123 rather of the speaking note in paragraph 146. Just make these brief points.
Well, we can read them.
Well, then you can read them, maybe.
Yes.
But we say that these are further indications of perversity which inform again against the reweighting of the family
You
line.
keep saying perversity, and I don't think you really mean
Well,
perversity.
I actually do in this
You
instance.
do you?
With regard to A in my idea, because we say that there's an ignorance of a material consideration, which is the actual emotional impact and behavioural impact on the child. But maybe, as you say, you can read those points. Unless there's anything else in particular that I can assist the court with, those are the submissions of the time. I'm grateful.
Not at the moment, thank you, Mr. Jones. So, Mr. Malik, can we just get your skeleton?
Yes.
As I indicated to Mr. Jones, we were very much assisted by both skeletons, so please don't think that you've got to read it out.
Absolutely. So, Milady and Milords will see that in my skeleton argument, I have addressed the issue of principle first, namely the interplay between section 117b(5) and section 117c of the 2002 Act. This is at paragraphs 25 to 32. Milady and Milords will see that I've then addressed the grounds of appeal in two parts. In the first part, I've addressed grounds 1 and 2 together because they attack the error of law decision. This is at paragraphs 33 to 37, and I've then addressed grounds 3 to 8 together because they are an attack to the remade decision. So what I propose to do in my oral submissions, of course subject to any observations, is to seek to assist the court in relation to the oral submissions that Miller and Friend has made in the opening. And I will take the points that Miller and Friend has made in the same order in which those points were made. So Milady and Milords will recall that the first point that Miller and Friend made was that section 117b(5) is not applicable at all in a case where the exception in section 117(4) is met. That is the primary argument that Miller and Friend advances. He says that where the exception in section 117c(4) is met, section 117b(5) should be disapplied. In my respectful submission, there are three difficulties for Miller and Friend. First, this argument is inconsistent with the clear language of the statute. Second, it is not supported by the authority. In fact, it is inconsistent with the authority. And third, it is wrong in principle and is inconsistent with the overall scheme of Part 5A of the 2002 Act. So very briefly addressing the 3 points in turn, you have the statutory provisions in the authorities bundle, tab 20. Tab 26. If you look at section 117A subsection 2, the language is clear, and I emphasize on the word must as it appears in subsection 2. So there is an obligation on the decision maker to have regard to the considerations. And then, my lady and my lords, will see that 2A says in all cases to the considerations listed in section 117B. Now, my learned friend, in my respectful submission, is seeking to insert words in the statute that do not exist. He, in my respectful submission, in effect asks the court to insert words save as where exception 1 applies after the words in all cases in subsection 2A. This, in my respectful submission, is not justified.
Let's give us that gloss again. Save.
Save as where exception 1 in section 117C applies. That's what, in my respectful submission, my learned friend asks this court to do, to limit the application of section 117B5. An acceptance of the submission that my learned friend has made, in my respectful submission, would be contrary and inconsistent with the words in all cases as they appear in subsection 2A.
There's another factor, isn't there, which is that the words in 117B6 are expressly in the case of a person who is not liable to deportation. Those words don't appear anywhere else in 117B.
Absolutely, my lord, and that was the point that I was hoping to make as the third point.
Right.
But my lord, the point essentially is that where Parliament intends to exclude the application of a provision in this part, it would say so expressly, as my lord has pointed out. So that, my lady, my lords, is the statute. Moving on to the authority, my lady, my lords, will recall that my learned friend referred the court to KO Nigeria, CI Nigeria, and EAA. Now, I do not propose to take the court to those authorities. Nowhere in those judgments it is said that section 117B5 is disapplied in cases involving foreign criminals. My learned friend has not shown any particular passage in those authorities that would support his proposition. The proposition that my learned friend makes, in my respectful submission, is inconsistent with Rupiah. You have seen Rupiah, it's the fourth authority in the authorities bundle. And if I may respectfully ask my lady and my lords to consider paragraph 49 of that judgment. That paragraph appears at page 5549 of the report. This is page 59 of the bundle. This comes under the heading section 117A2A. You will see that Lord Wilson there has emphasized on the words in section 117A to A, the words that I've just shown you. And if you look at the second sentence, it says, so in respect of the considerations in section 117B5,
So which paragraph are you reading from?
this is paragraph 49, my lord, second sentence. Parliament's intention is to have, Parliament's instruction is to have regard to the consideration that little weight should be given to a private life established by a person at a time when the person's immigration status is precarious. That, Lord Wilson says, is Parliament intention, Parliament's instruction without any qualification. So the suggestion that this provision does not apply at all, where the first exception applies, in my respectful submission, is simply untenable. Thirdly, Milady, my lords, the overall scheme of Part 5 of the 2002 Act. So I have made a point in answer to my Lord Justice Phillips' question that where Parliament intends to exclude the application of certain provisions, this part it would say so expressly. But if one looks at Part 5 of the 2002 Act, tab 26, you'll see that section 117B and section 117C has two distinct targets. Section 117B addresses the public interest in immigration control. That's what section 117B subsection 1 says. Under the heading public interest considerations applicable to all cases. And section 117C on the next page addresses the public interest in deportation of foreign criminals.
As additional.
Absolutely. So it could not be right, in my respectful submission, for a person who meets an exception that addresses the target of deportation of foreign criminals to be an answer to the immigration related factors that appear in section 117B.
Just make that submission again.
So the submission is that it is wrong in principle to submit that a person's ability to meet the exception in section 117C, which addresses the public interest in deportation of foreign criminals, answers the public interest considerations in relation to immigration control as they appear in section 117B. But rather fundamental point here is that if my learned friend is right, as Milady pointed out when my learned friend was making his submissions, it places foreign criminals in a more favorable position compared to a person who hasn't committed a criminal offence. A foreign criminal, on my learned friend's case, will succeed if the exception is met. A person who has not committed a criminal offence will not succeed even where that exception is hypothetically met. That, in my respectful submission, cannot be right.
Just even go a bit further than this. It seems to me that if you're dealing with a 117C6 case of at least 4 years, there is no concept of exception 1 and exception 2. They don't apply because those exceptions are expressly limited to those who are sentenced to a period of 4 years, or not 4 years or more. So they expressly do not apply. So when you look at 117C6, you could stop at the word, Parliament could have stopped at the words very compelling circumstances. But it then adds the following words over and above those described. That's by way of limitation. it's telling you that various circumstances have to be over and above those described. It's not saying that exceptions 1 or 2 have to be satisfied.
Absolutely, and the jurisprudence makes it clear that a person, at least hypothetically, can meet section 117C6 even where the exceptions are not met at all.
It could be an entirely different factor, such as disability or something like that.
Absolutely,
Yes.
Absolutely. The case law makes it clear.
Yes.
And then you have the point that my Lord Justice Haddon-Cave put to my learned friend when he was making his submissions, that if one looks at section 117B 4, you'll see that relates to a person whose residence in the United Kingdom is unlawful. And subsection 5 relates to the residence that is precarious. And that is the point that Lord Wilson made in Rupiah, that the fact that a person has limited leave to remain, the person is residing in the United Kingdom lawfully, does not mean that that person's status is not precarious, that will remain precarious, short of indefinite leave to remain. Section 117B5 would apply. And if one compares that scheme, the scheme in subsection 4 and 5 of section 117, with section 117C4, you'll see that the phrase lawfully resident also appear in that section. So the scheme is premised, in my respectful submission, on the basis that a person can have lawful immigration status, yet his status would be precarious for the purpose of section 117B5. So for these reasons, I submit respectfully that what my learned friend has said is inconsistent with the scheme of these provisions, and it is wrong, in principle, lead, in my respectful submission, to absurd consequences. Now, in the course of his submissions, my learned friend made a point that his proposed construction of these provisions has the benefit in that it would lead to consistency in the decision-making process. But if one looks at section 117C6, it becomes clear that Parliament's intention was to avoid setting a hard-edged question, a test that can then be applied consistently to all cases. That was the reason why Parliament used the phrase very compelling circumstances. An assessment is fact-specific. There are no hard-edged questions. And in my respectful submission, what my learned friend categorizes as a benefit, in my respectful submission, would undermine the carefully crafted distinction between medium and serious offenders. So Parliament identified relatively hard-edged tests in respect of a medium offender, but a broader test in relation to a serious offender. So there is, in my respectful submission, no benefit whatsoever in accepting the argument that my learned friend has put forward.
Parliament sometimes does this, but the mere fact that you have a hard-edged test for one category doesn't mean that you have to have a similar test for another.
Yes, my Lord, and looking at section 117C 4 and 5 and comparing those subsections with subsection 6, it's quite clear in my respectful submission that Parliament's intention was that those who have committed serious crimes, those who have been sentenced to a period of imprisonment for at least 4 years, are to be dealt with in a significantly different manner than medium offenders.
Because from a matter of administration, simple administration, you may wish to clear away a large category, but leave more flex in relation to the remainder,
Absolutely.
which are maybe more difficult to have more considerations to deal with.
Absolutely, my lord, and the reason, in my respective submission, is obvious. Now, the next.
I just want to ask one other aspect about this. It seems to be one of the difficulties in the argument is that 117C4 and 5, but looking particularly at 4, isn't dealing with weight, is it? There's no question of any weight being given to these considerations. It's only saying if these three factors arise, then there's an exception to the presumption of deportation being in the public interest. So
Yes.
we're not considering here at all what the weight of the private life is.
That's absolutely right, my lord. Yes.
So if you have that, and also you have C, very significant obstacles to integration into the destination country, then that's the end of the presumption under 117C. So I'm not sure why that has anything to do with the application of the question of what weight you give to private life.
My lord is absolutely right. Of course, this is a case where Section 117C6 applies.
Yes.
The appellant is a serious criminal. The position might have been different. There might have been a room for a greater argument in relation to a case that falls within the medium category.
Speaking for myself, I respectfully agree with my lord's point that C4, A, B, and C look like threshold points. Once you get past the threshold, doesn't matter how far you are, you tick the box and you're out.
Yes.
But you submit it's different in relation to C6 because it's a much broader analysis, and as indeed some of the cases appear to suggest.
Absolutely, Lord. So these are the submissions that I wanted to make in response to what my learned friend has said on this issue. You have my detailed submissions on the interplay between the statutory provisions in my skeleton argument. So my learned friend's next argument was that the upper tribunal should have allowed the appeal at the error of law stage. And in answer to a question by my learned friend also made a submission that in the alternative, the upper tribunal should have remitted the appeal to the First Tier Tribunal. Now that isn't a point that was apparent from the grounds and skeleton. And Milady, when my learned friend was making his submissions, made an observation that there wasn't any guidance to the upper tribunal as to what to do, whether to retain the appeal or to remit it. I just feel obliged to draw to the court's attention that there is some guidance in the form of a practice direction by the senior president. I have printed copies of those practice directions. If I may just hand these up for completeness.
Yes, thank you. Very helpful.
Good. Thank you. So I've given a copy to my learned friend. So if I may show my lady and my lords what that guidance is, because that would answer at least a part of the submissions that my learned friend has made. If I may ask my lady and lords to go to practice statement 7. It falls under the heading disposal of appeals in the upper tribunal.
Yes.
7.1 concerns the circumstances in which a decision is set aside, but see 7.2 and 7.3. 7.2, the upper tribunal is likely on each occasion to proceed to remake the decision instead of remitting the case to the First Tier Tribunal, unless the upper tribunal is satisfied, and there are two exceptions. The exceptions do not apply here. And 7.3 says that remaking rather than remitting will nevertheless constitute the normal approach to determining appeals where an error of law is found, even if some further finding of fact is necessary. So the judges in the upper tribunal are positively encouraged by the senior president to retain the appeals, remake the decision, as opposed to remitting the matters back to the first tier tribunal. So what the upper tribunal did in this case is entirely consistent with this guidance. In the course of his submissions, Miller and Friends submitted that the upper tribunal was wrong not to allow the appeal outright or not to remit the appeal to the first tier tribunal. In my submission, it's not enough for Miller and Friend to say that the upper tribunal has got it wrong. The appeal to this court is available only on a point of law. So Miller and Friend has to demonstrate not only that the upper tribunal was wrong, but that the upper tribunal was wrong in law. In my submission, the decision as to whether to remit the matter to the first tier tribunal, to retain it at the upper tribunal, to invite further evidence, to have another hearing, are all case management matters for the upper tribunal. There is no basis in my respective submission to interfere with the way in which the upper tribunal has dealt with those case management matters. No error of law arises in my respective submission in that respect. But in any event, the reasons given by the upper tribunal for retaining the appeal and adjourning it for another hearing are entirely cogent. Those reasons are set out at paragraphs 56 to 60 of the error of law decision, page 92 of the appeal bundle. Now, if you look at paragraph 57, the court has already looked at that paragraph. The upper tribunal is not saying that the first tier tribunal has made a finding that is not justified. The point made in the first paragraph, first sentence of paragraph 57, is that there has been no clear finding in relation to the point that is identified. And then the point is made that the first tier tribunal has found that the first exception is met, but that exception, as the court knows, is directed to the consequences on return as opposed to the private life in the United Kingdom. And the upper tribunal was absolutely right in saying towards the end of page 92 that this wasn't a case where the only outcome was to allow the appeal outright. As
in line 3, sorry, Malik, line 3, no clear finding to this effect. What effect is the tribunal referring to? The end of the first sentence.
This is in my submission reference to the phrase particularly strong as
Yes.
it appears in the earlier sentence. So no clear findings yet.
Thank you. Sorry to interrupt. Thank you.
Now if you then look at just at the end of page 92, the upper tribunal acknowledged the obvious factors that supported the appellant's case, that he had a particularly strong private life, but said that it was necessary to view those matters in the context. So that is the first key reason given by the upper tribunal for retaining the matter and having another hearing. The next reason is given in the next paragraph, paragraph 58, that it was important, says the upper tribunal correctly in my submission, to directly address whether in this particular case there is a sufficiently strong private life for the purpose of section 117b(5) as explained in here. that point was not directly addressed by the First Tier Tribunal. And the third and final reason given by the upper tribunal is at paragraph 59. You'll see that the appellant was released from prison in August 2018. The First Tier Tribunal heard the appeal in October 2019, and this decision was taken in July 2019. And it was entirely legitimate for the upper tribunal to ask for the assistance as to the present circumstances and updated evidence. That was not available at that hearing, and it was entirely legitimate in my submission for the upper tribunal to ask the parties to provide a clearer picture to enable it to remake the decision.
That third issue that you referred to, Mr. Malik, could have been equally applicable to it being remitted to the First Tier Tribunal. So I think your submission is that in accordance with the practice direction, the upper tribunal followed the practice direction because it seems to be that the default position, save for the considerations in 7.2a and b, is that the upper tribunal will, and that in the absence of the matters in 7.2a and b, the upper tribunal gave reasons as to why they were going to not only, well, I don't know if they gave reasons why they were going to retain it, but what they intended to do in retaining it and remaking the decision.
Lady is absolutely right, but there is lady, with respect to a further point, which is that if you look at the next paragraph, paragraph 60,
yeah,
this is where the upper tribunal said that, well, the likelihood of any further evidence is limited, the factual findings are preserved, and in all the circumstances it was appropriate to retain the appeal at the upper tribunal.
Yeah, and then it goes on to indicate the directions.
Yes, so the decision is set aside. The parties are given an opportunity to submit further evidence, position, statement, and so on and so forth. So where for example,
it isn't restricting the appellant, is it, in the nature of the evidence he can submit?
Absolutely. So where a decision in a complex case is set aside in its entirety, and remaking requires extensive oral evidence, cross-examination. So that is the sort of case that would be remitted to the First Tier Tribunal in accordance with the practice direction, because that would be a case where the nature or extent of the judicial fact-finding would make it necessary for the decision to be remade at the First Tier Tribunal, or a case where there was no fair hearing at all. But in a case of this sort, in my respectful submission, it was entirely justified for the upper tribunal to retain the appeal and to remake the decision at a subsequent hearing.
What do you say, Mr. Malik, about the second sentence in paragraph 59, which Mr. Jones highlighted? Both representatives made it clear that they were content to rely solely on the FTT's findings of fact and factual evaluations. These should be clearly preserved.
Well, that, in my submission, there can be no doubt that is the reference to the underlying findings of fact and the evaluation of those facts, as opposed to the evaluation that is required under section 117 C6, because that, of course, is the evaluation that the upper tribunal would conduct.
And what they're not saying is that the decision is preserved, save insofar as something can be shown to be different to make us change our mind, or change the mind, as it were.
That's right. So in my submission, there's nothing in these paragraphs that would even begin to support a submission that the upper tribunal had shackled itself or was seeking to do so in the way that Miller and Friend has sought to identify. Now, Miller and Friend, Lady and Lords, will recall that took the court at this point to the judgment in LS to make a submission that the upper tribunal was not entitled to do what it did. Now, that authority in my submission provides no assistance whatsoever to the appellant. If I may take my lords and my lady to that authority, this is tab 22 of the authorities bundle. Now, one thing that is immediately clear from the very first page, that this case was decided in 2008. This was before the tribunal, the Courts, Tribunals and Enforcement Act 2007 came into effect. So this isn't a case that addresses appeals from the First Tier Tribunal to the Upper Tribunal. When that case was decided, there was a single appellate body, the Asylum and Immigration Tribunal, where an immigration judge would make the first instance decision, and if that decision discloses an arguable error of law, it would be reconsidered by the same body, but by a different judge. And that was the premise on which that case was decided. Now, if you go to paragraph 15 of the judgment, you will see that the relevant statutory provisions are set out. And those are section 103A of the Nationality, Immigration and Asylum Act 2002. Now that provision was repealed when the Upper Tribunal and the First Tier Tribunal came into effect. Paragraph 17 is a reference to DK. And if you look at paragraph 17, you will see that that was a decision, as it says, on the scope of the tribunal's jurisdiction in relation to reconsideration. So the reconsideration of its own decision, and by reference to the rules that are no longer in force. What is said at the next page is telling. So if you go to the next page, this is the quotation from DK. This is page 3. And if I may ask my lords and my lady to look at that quotation. The very first sentence relies exclusively on the concept of reconsideration by the same body. So here the First Tier Tribunal has made a decision. There is an appeal to the Upper Tribunal, and the Appellate Tribunal is now remaking the decision. The concern there was that one judge would make a decision and another judge would reconsider it, and it wouldn't be right in principle for the other judge to depart from the first judge. Middle of that paragraph, it is not a rehearing. Parliament chose not to use that concept, presumably for good reasons. But here, there is a rehearing. That is the concept that was introduced by sections 11 and 12 of the Tribunal Courts Enforcement Act 2007. Now this reasoning played an important part in the analysis. If you look at the analysis next, see paragraph 19 of the judgment, page 521. If you look at the middle of that paragraph, you'll see a reference to DK. And again, the emphasis is on the concept of reconsideration by the body that originally made the decision, and the need to avoid the apparent irrationality of the same tribunal reaching inconsistent decisions on the basis of same evidence. The situation here is now completely different.
Can you give the reference to the Courts and Tribunals Act?
Lord, that is the tribunals Courts Enforcement Act 2007. If you have my skeleton argument, I have referred to the relevant provisions.
It's at tab 28 if that assists.
Thank you.
Relevant of the authority.
I'm grateful.
Yes, thank you.
So it's paragraph 24 of my skeleton. You have the provisions behind tab 14. So there is an initial appeal to the first tier tribunal, then an appeal to the upper tribunal. The upper tribunal, if finds an error of law in the first tier tribunal, may then remake the decision and see section 12 subsection 4, paragraph 24 of my skeleton. In acting under subsection 2b2, this is when the upper tribunal remakes the decision. The upper tribunal may make any decision which the first tier tribunal could make if the first tier tribunal were remaking the decision, and B, may make such findings of fact as it considers appropriate. So in principle, in my respective submission, in this case, it would have been open to the upper tribunal to completely depart from the findings made by the first tier tribunal and remake all those findings. But this is not what, of course, the upper tribunal did. In this case, the upper tribunal evaluated, conducted the evaluation required on the basis of those circumstances. So for these reasons, I respectfully submit that there's nothing in grounds 1 and 2. The upper tribunal's error of law decision discloses no error of law. The upper tribunal was entitled, in fact right, to set aside the first tier tribunal's decision, retain the appeal, and remake the decision in the way in which it did. Miller and Friend then made submissions on the remade decision. And before addressing the court as to the submissions that Miller and Friend has made, may I respectfully make 5 short propositions, and I invite the court to have regard to these propositions in considering the submissions that Miller and Friend has made. First, so these propositions are about the approach that this court should adopt to the findings, to the factual findings and evaluation made by the upper tribunal. First, the upper tribunal is a specialist tribunal, and this court should not rush to find an error of law simply because this court might have reached a different conclusion on facts or expressed those facts differently. The authority for that proposition is A. Sudan. It's behind tab 10 of the authorities bundle, paragraph 30. I do not propose to take Miladian law authority now. Second, a relevant point is not expressly mentioned by the upper tribunal.
I'm just looking, Mr.
Yes.
Malik, to see whether you actually refer to these propositions in your skeleton.
Lady, not in a bullet point format, but if you look at paragraphs 38 to 39 of my skeleton, you have
It's just so that we can cross-reference
yes,
our notes. Mr.
paragraphs 38 and 39. So secondly, where a relevant point is not expressly mentioned by the upper tribunal, this court should be slow to infer that it has not been taken into account. The authority for that proposition is MA Somalia. It's behind tab 9, 5.
Well, we've also got to be very careful if there's an express indication from the upper tribunal that they've taken certain facts into account.
Absolutely. So this is one of the points that I had on my list, that even if the upper tribunal had not said what it said, its decision would have been entirely lawful. But in this case, the upper tribunal expressly said that it was taking all these matters into account. So there is no basis in my respectful submission to assume that what the upper tribunal said was taken into account wasn't in fact taken into account. Third, when it comes to the reasons given by the upper tribunal, this court should exercise judicial restraint and should not assume that the upper tribunal has misdirected itself in law just because not every step in the reasoning is fully explained. The authority for this proposition is Jones versus First Tier Tribunal. It's the 8th authority in the authorities bundle, paragraph 25. Fourth, this is important in the context of a particular point that my learned friend has made. The issues that the upper tribunal is deciding and the basis on which the upper tribunal reaches is its decision on those issues may be set out directly or by inference. And the authority for that proposition is ex parte see paragraph 39 of my skeleton argument. And fifthly and finally, the upper tribunal judges are to be taken to be aware of the relevant authorities and to be seeking to apply them without needing to refer to them specifically, unless it's clear from the language that they have used that they have failed to do so. And the authority for that proposition is AA Nigeria, paragraph 34. It is the 13th authority in the authorities bundle. So when Milady and my lords will consider the submissions that my learned friend has made having regard to these 5 propositions, which are well settled and not controversial as I understand, Milady and my lords will see that there is simply no force in grounds 3 to 8. Now the first point that my learned friend made in relation to the remade decision was about the rehabilitation issue. There are 2 answers to that issue. The first answer is based on the judgment of this court in Hache, Iraq. That authority is behind tab 14 of the authorities bundle. And the relevant paragraphs are paragraphs 138 to 142. And if you look at paragraph 138 first, now this is where Lord Justice Underhill referred to the judgment of Lord Justice Mobic in the case of Dansu. And if I may ask Milady and Lords to consider the quote in that paragraph, in particular the concluding part of that quote that appears at page A349. The point there that is made that one aspect of the public interest in deportation is to prevent a person reoffending, and in respect of that particular aspect, rehabilitation may well be relevant, but that's not all. As Lord Justice Mobic says, that is only one of the factors that makes it conducive to the public good to deport criminals. Other factors include the need, and I'll leave Milady and Lords to read that paragraph. So the fact that a person has rehabilitated in the sense that there is no risk of reoffending does not answer, in my respectful submission, this other aspect of public interest.
Paragraph.
Paragraph 138, the quotation in that paragraph, Lord, if you look at page 1373 of the report,
Yes, I've got it.
just above letter B. It must be borne in mind. Line 3 on that page. So the fact that a person has rehabilitated says nothing in relation to the interest to deter others from committing criminal offences. Now, in that context, Lord Sandhill said at paragraph 141, and this really is the height of the analysis from the appellant's perspective, that it cannot be said that rehabilitation cannot be excluded from the overall proportionality exercise. If you then go to the next page, this is what Lords and Milady highlighted when Miller and Friend was making his submissions, that the weight to be given to that factor would depend on the particular facts of the case, but it will rarely be of great weight, bearing in mind the point that I've just made. And there is then a point that the tribunal, that any tribunal would probably be very cautious about their ability to make a finding as to the risk of reoffending. So in this context, where the fact that a person has rehabilitated does not really answer the public interest in deportation, and that it will rarely be of great weight, the point that Miller and Friend has made in my submission takes the case nowhere. So that's the first way in which I address the point. Secondly, if you look at the upper tribunal's decision, this is at paragraphs 28 and 29. Remade
Page
decision,
number, please.
page 33 of the bundle.
Thank you.
Paragraph 28, you'll see that the upper tribunal expressly took into account the detailed evidence summarized by the upper tribunal as to the appellant's good behavior. This is fourth line at paragraph 28. So that evidence, the evidence of good behavior, law-abiding context, positive attitude was expressly taken into account. And you'll see that the upper tribunal then referred to many sporting letters that were in the evidence. But that, of course, is not the complete picture. The upper tribunal also added, as it was entitled to do so, that the appellant has only been out of prison since August 2018 and has not been tested outside of prison environment for a very lengthy period of time, or even a significant period of time in the context of the lengthy period that he offending, an entirely legitimate observation. And the upper tribunal then gave further reasons as to that. But paragraph 29 makes it absolutely clear that the upper tribunal was attaching positive weight to these factors. So that really is in my respective submission the answer to the point. Now, if the upper tribunal had completely excluded this positive evidence from its consideration, there might have been a ground to argue that was inconsistent with HA Iraq. But given that the upper tribunal is attaching weight to the evidence, in my submission, it cannot be said that there is any error. the upper tribunal then referred to the point that I have just made, that rehabilitation only addresses one aspect of public interest, and then there is a reference to Benviuga, paragraph 84. Now this, what is quoted in italics wasn't disturbed by this court in Hache, Iraq. What is said is clearly correct, that a person is expected to comply with the law. The fact that a person has not committed criminal offences is hardly a positive factor. So despite that evidence, the upper tribunal concluded at paragraph 31 that the public interest in the deportation remains very strong. And if you look at paragraph 31, you'll see the reasons for that essentially are about the legitimate aim to prevent crime and disorder and maintaining immigration control. So in my respective submission, no error of law arises from the way in which the upper tribunal dealt with this issue.
So in paragraph 142 of HA Iraq, what point do you submit that Lord Justice Underhill was differing from Lord Justice Hamlin on paragraph 142?
Yes.
HA Iraq.
Now, if you go back to paragraph 134, there is an application for permission to appeal that is presently pending before the Supreme Court, based on the tension between Benviuga and Hache, Iraq. The Secretary of State's position before the Supreme Court is that rehabilitation is simply irrelevant. But that is not the submission that I make before this court. I accept that it cannot be excluded. To explain the difference between two approaches, if you look at paragraph 134, now this is where Lord Underhill referred to Benviuga, and you will see that Lord Underhill referred not only to this point, that rehabilitation involves no more than returning an individual to the place the society expects him to be. But then there is this additional point that rehabilitation will generally be of little or no material weight in proportionality balance. So this really is the point that was decided in Benviuga, that rehabilitation is of little or no material weight. Now, Lord Sandhill departed slightly, in my respective submission, from that view. And if you look at paragraph 142, you'll see that Lord Sandhill said that what was said in Benviuga wasn't, at paragraph 84, wasn't part of its ratio. So where the two courts disagree essentially is whether rehabilitation is completely irrelevant or it is of some relevance. Benviuga says that it is of no material weight. Lord Sandhill says that, well, it can be given some weight that would depend on each case, but it will rarely be of great weight in deportation cases. So Hache, Iraq causes no difficulty, in my respective submission, to the Secretary of State, because the upper tribunal at paragraph 29 attached weight in the appellant's favour to the evidence of rehabilitation. Now, my learned friend then made a series of submissions categorizing the upper tribunal's decision as unlawful and irrational on the basis that it attributed, he says, inappropriate weight to certain factors. Now, the question as to how much weight is to be given to a particular matter is in my submission, is a matter for the upper tribunal. As long as the matter is taken into account, the upper tribunal is entitled to attach little weight, a great weight or no weight to that factor, and that would not give rise to illegality or irrationality. Miller and Friend also repeatedly submitted that the upper tribunal, the conclusions reached by the upper tribunal are perverse. That's a very, very high hurdle. And in my respectful submission, if on a close analysis, the submissions that Miller and Friend have made are merely a robust disagreement with the reasons given by the upper tribunal, but it's nothing more than a disagreement. So the first attack in relation to the other reasons given by the upper tribunal relates to paragraph 48 of the upper tribunal's decision. Now that paragraph appears at page 39 of the bundle, and Miller and Friend took issue with the final sentence of this particular paragraph. This is where the upper tribunal said that the history of offending and lengthy imprisonment have weakened the integrative links and the overall strength to his private life. And Miller and Friend argued that this was inconsistent with CI Nigeria. If you look at the same paragraph, paragraph 42, you will see that the upper tribunal took account of paragraph 72 of CI Nigeria and was seeking to apply it. If you go back to page 38 and consider paragraph 47, you will see that the upper tribunal there referred again to CI Nigeria and was seeking to apply it in that case. This is right at the end of page 38, fourth last line.
So what was the first reference to CI?
This is, first reference is paragraph 47.
And the second one?
The second one is 48.
Thank you, sorry.
I think you also mentioned 42.
Yes.
So that
That's
seems,
UNA.
yeah, it seems to be referring to UNA.
Yes. But the fundamental flaw in my respective submission in the argument that Miller and Friend makes is that if one looks at paragraph 45 of the upper tribunal's decision, the upper tribunal endorsed the undisputed fact that the appellant is socially and culturally integrated in the United Kingdom. So the first exception is met. CI Nigeria provides no assistance to the appellant, because if one looks at CI Nigeria, it's tab 16 of the bundle, it's quite clear that the court there was not addressing section 117C6. The court was addressing the first exception in section 117C4. The upper tribunal in that case had decided that exception was not met because of the appellant's criminality, and that was the subject of the challenge. That isn't this case. So tab 16 of the authorities bundle, page 388, relevance of offending and imprisonment. So the upper tribunal is this court is addressing a point that was resolved in the appellant's favor in the present case. But even taking the case at its highest, if you look at the last sentence at paragraph 61, in such ways, criminal offending and consequent imprisonment may affect whether a person is socially and culturally integrated in the United Kingdom. So the upper tribunal in this case could have legitimately said, in my submission, that the first exception is not met. But of course, this is not what the upper tribunal said.
So CI was a 117B4
Absolutely, yes. So you have taken a note, my lord, my ladies, of...
Sorry, C4, my lord.
C4, sorry,
C4.
C4. Yes. Thank you.
C4. So you've taken a note of the final sentence in paragraph 61, that even in the case of an exception, criminal offending may affect social and cultural integration. And then see paragraph 62, that an assessment requires an assessment of a number of factors. If you then go to paragraph 75, again taking the appellant's case at its highest, assuming that this is a case about a medium offender where exception 1 is an issue, even in that case, this court says at paragraph 75 that the upper tribunal was right to say that social and cultural integration can be broken by criminal offending and imprisonment, and that is a fact-sensitive question. The upper tribunal in this case has not gone that far, and the point there then is made is that if the upper tribunal concludes that there is a break in that there isn't social and cultural integration, then the upper tribunal must give adequate reasons. So the final reference in this authority is to paragraph 78. This is where the court addresses the concept of social and cultural integration and makes a point that it's a composite concept. Again, the court was addressing a different question altogether. In this case, as I have demonstrated, the upper tribunal commenced its assessment by accepting that the exception is met. There is social and cultural integration. The upper tribunal then, for the purposes of the assessment under section 117C6, considered whether there were very compelling circumstances, and in that context made the comment that appears at the end of paragraph 48, that the history of offending and lengthy imprisonment have weakened the integrative link and the overall strength of his private life. That was in the context of the assessment of very compelling circumstances test. The way in which the upper tribunal has dealt with this particular point, in my submission, discloses no error of law.
So whereas, in simple terms, 117C4, exception 1, is in a sense a threshold exercise. Do you pass the threshold? 117C6, the very compelling circumstances test, is a broad evaluative exercise.
Yes, Lord, it is. So Miller friend also made a submission that there was no substance, he says, in the conclusions reached by the upper tribunal. That to me appears to be a complaint that the upper tribunal has not given adequate reasons for its conclusion. The reasons are extensive, careful, and in my respectful submission, plainly adequate. The final submission that Miller friend made was that the upper tribunal's rebalancing of the family life limb was wrong. And I respectfully repeat my submission that it's not enough for Miller friend to demonstrate that the upper tribunal's assessment is wrong. That is mere disagreement with the upper tribunal's conclusion. Miller friend has to demonstrate an error of law. So the upper tribunal has dealt with the family life limb of the claim at paragraphs 32 to 36. Miller friend's submission, I think, was that the upper tribunal has not taken account of the first year tribunal's findings and have departed from those findings. That submission is not justified on the language that the upper tribunal has used at paragraph 32. We bear in mind, the upper tribunal says, the First Tier Tribunal's detailed findings under the subheading family situation. The upper tribunal is proceeding on the basis of those findings, but then makes its own assessment as it is obliged to do so. And if you look right at the end of paragraph 32, after adopting the First Tier Tribunal's findings and proceeding on the basis that exception 2 was met, the upper tribunal then turned to consider whether there was evidence to support the claim that disruption of family life goes over and above the level of undue harshness, that the upper tribunal was required to do so under section 117C6. The upper tribunal then concluded that the unduly harsh test was met, but it was only just met, last sentence of paragraph 33. But it makes no difference for the reasons that I have identified earlier. The assessment required under section 117C6 is a completely different assessment in nature.
With a medium offender under 117C4, the tribunal doesn't have to make, in a sense, an evaluation of precisely how far past the threshold. It's a binary. You either pass it or you don't. So it doesn't have to drill into that sort of detail or express it.
Absolutely. So if the threshold is met in the case of a medium offender, the First Tier Tribunal will allow the appeal. If the threshold is not met, then the tribunal will then conduct the assessment under section 117C6.
What Mr. Jones says is, well, the same should obtain for the C6 analysis.
But that...
And you've already explained, you say that on the wording, and for all other reasons, that is not the exercise that Parliament intended.
That's right. So, at the conclusion of his submissions, my learned friend referred to the judgment in Hache, Iraq, and said that the approach taken to the unduly harsh test by the upper tribunal was not consistent with that authority. But this is a case where the upper tribunal has accepted that the unduly harsh test was met. Hache, Iraq, therefore, does not assist insofar as that point is concerned. But when my lords and my lady will consider Hache, Iraq, you'll see that that was a case about a medium offender. The upper tribunal had found that the consequences of the deportation would not be unduly harsh, and this court said that the unduly harsh test was not properly applied by the upper tribunal. No such issue arises in this case. So for these reasons, in my respective submission, nothing in the oral submissions that my learned friend has made justifies interfering with the upper tribunal decision. I have, in my submission, sought to focus on the oral submissions that my learned friend has made. The written argument is addressed in my skeleton argument. So unless I can assist my lady and lords any further, these are my submissions.
Just on a point of detail, Malik, it's right, isn't it? We just turned to paragraph 23 where you've set out conveniently 117C that it's right. In NA Pakistan, it was held that there were words missing from 117C3 in the case of a foreign criminal who's not being sentenced for 4 years or more. Exceptions 1 and 2 apply, and it was found that there'd been an oversight and the words, unless very compelling circumstances, as per 117C6, should have been added by the draftsman.
Yes, so
the courts decided that that was an obvious error.
yes, the point there was that if in a case of foreign, in a case of a serious criminal, the upper tribunal would make the broad assessment of very compelling circumstances, but not in the case of a medium offender or who would not benefit from the exception. But of course, that isn't a point that would trouble the court in this case, because this is a case about a serious offender.
The other point of detail, you referred to Lord Wilson and phrase general normative guidance. In this context, what does general normative guidance mean?
That in my submission is a reference to the way in which Section 1171, Section 117A2 is addressed. So
you refer to in paragraph 26.
Yes.
So line.
Yeah. So in considering public interest consideration, the court or tribunal must have regard to these considerations. So the duty is to have regard to these considerations, and there comes a degree of flexibility in the sense that having regard to these factors, it is open to a tribunal in principle to allow the appeal, despite the fact that a person's immigration status is precarious. So that in my understanding is a reference to having regard, the words having regard as they appear in Section 117A2.
Thank you.
Good. Very good.
Mr. Jones.
My lady. I endeavoured not to repeat my submissions this morning and just focus on the particular point that my friend flagged up by reference to each of the steps, if that's convenient. Briefly, with regard to step one and the construction issue, if you like, which is what my own friend focused on, it didn't deal with our second position, which is concerned with the proposition that satisfaction of cultural and social integration for the purpose of 117C4B should be regarded as sufficient to surmount the rupiah threshold. I'll assume that that's objected to, because otherwise I presume we wouldn't still be here, and the court will make its own judgment on that, and you have the written argument as well as my oral submissions. So as far as the construction point is concerned, let's make these observations. My own friend suggested that with regard to the proposition that Parliament would have written in to Section 1172A or B, that these the provisions in Section 117B, 4 and 5 would not operate in respect of the exceptions, if that is what it had intended. The fact of the matter is that whilst it did not do that, the Supreme Court in KO identified that that's what the statutory process meant. The consequence of inclusion within the exceptions in 117B6 or the exceptions in 117C, 4 and 5 is that the general rules in the preceding section don't apply. Now, Parliament didn't write that in to the statute either, and I've dealt with that in the speaking note at paragraph 16. So it is not an answer to our submission to say, well, if Parliament had intended that, it would have been coherently communicated in the legislation, because the legislation, as we've already said, is defective in the sense that it is not, defective is the wrong word, it is incomplete in its articulation. It's been necessary for this court to interpret the intention of Parliament by reference to the broader construction of the statutory provisions. Now, if it is permissible applying that interpretation to accept the general rules in 117B with regard to the exceptions, it is not, as we submit, a significantly greater leap to step on and say that when one is looking in 117C6 to whether or not there are very compelling circumstances above and beyond those exceptions, that one should factor in that same consideration to that evaluative exercise. And and we then come back to all of our submissions about how that will actually, we submit, assist the clarity of the decision-making process. And what What I would suggest to your Lordship, your Ladyship, is that the way that these provisions should be looked at is effectively as a kind of a staged process, a flowchart, if you like. If you meet one aspect of the provision in 117C4, for example, that has implications, even if you're a serious offender, for the subsequent evaluation in 117C6. You do not discount and ignore the consequences. Authority says, perform your assessment of very compelling circumstances by reference to the exceptions within the statute. And again, I've given you the references for that in the speaking note. And so all we are advocating is a logical connection be drawn between serious offender cases where the exceptions are met and that the Parliament's intention with regard to the operation of those exceptions then be transposed into the evaluation of the very compelling circumstance test. And I think if I could just respond to Malone, your Lordship's question about the way that the exceptions operate and whether there is any form of evaluative exercise to be performed with respect to those who are within the exceptions. I respectfully submit that there is. In each of the private and family life exceptions, there is an evaluative exercise to be performed, a weighing to be performed before one reaches the threshold for inclusion. With regard to inclusion within 117C4, although the straightforward exercise with regard to determining lawfulness of residence and half your life here in that capacity, a more evaluative and nuanced assessment using the language of the upper tribunal itself then comes into play with regard to the evaluation of whether a person is culturally and socially integrated, and indeed then whether or not they will face very significant obstacles with regard to integration. Now those are not, that is not an exercise of evaluation or weighting with regard to the public interest side of the equation. I absolutely accept what your Lordship says is that for the purpose of the exception there is no, it is not feasible for those who are eligible to qualify under them to introduce further public interest considerations into that analysis. But so far as the analysis of inclusion, it is a CI itself identifies. It's a complex, factual exercise which requires considerable weighting and evaluation of private and family life interests.
Well, I think the point I was making was that evaluation is evaluation, but there's no balancing exercise involved.
Then perhaps we're getting closer to a point where the balance is easier to discern, because as further decisions are promulgated, such as HA-Iraq, we have greater clarity, for example, as to exactly how one should understand and apply what undue harshness means. But it is still a complex exercise of weighting and discerning whether or not the interests which these provisions are supposed to protect are actually in play to a degree where they cause the exceptions to operate. So I think that is the line I would suggest is drawn is with regard to the exceptions is one excludes public interest beyond that which is described generally within the fact that you are a foreign offender who's susceptible to deportation, but everything else is open and has to be weighed and assessed. And so on that basis, I respectfully suggest that the exercise that one performs when one steps on to the 117C6 is not so very different, save that we say certain public interest considerations can be brought in again by reference in particular to section 117C3, which is the more seriously you offend, the greater the weight there is in favour of deportation. So there's certainly a big public interest consideration there. And for those that don't meet the exceptions in that category, yes, precariousness is in play. Yes, lawfulness is in play. But for those that do, you can be informed in that evaluation by your inclusion within the exceptions previously and can discount them. Or at least the issue of immigration status should not form a part of that evaluation. So again, that's how we put the case, and we say that is, as I said at the beginning of our submissions, consistent with what Parliament intended as to how this scheme was supposed to operate. Using all elements of the scheme, instead of hiving off 117C6 and saying, well, this stands apart and is uninfluenced or informed by anything that comes before. In fact, a more coherent approach, a more sensible, rational approach, respectfully, and a more consistent approach with what Parliament intended is to actually use themselves to inform that ultimate evaluation.
You're saying that you don't take into account 117B5.
But only in the very limited circumstances of this case and other cases where the exceptions apply, where Parliament has augmented its description of an individual's immigration status so as to enable discounting of precariousness as a factor. So I do not by any means say generally that is what happens, but simply by looking at the interplay between 117B4 and 117B5 or 117C4, one can do that in this particular instance, and one should do that.
It seems to me what you're saying is that you should effectively take into account exception 1, which expressly doesn't apply, but not take into account 117B5, which expressly by the statute should be taken into account.
On the same logic, though, my lord, as KO applied to discount 117B5 in the first place with regard to those who do fall within the exception. It is a consistent, we say, rational approach, which will deliver more reliable consequences with regard to determination. If I could then just go on to step 2, the issue of remittal. You heard me this morning, you have my written note. I just want to respond, if I may, to the point that my friend made by reference to the practice statement. I would stress that by no means did I, and if I made this submission, I did it inadvertently, that I intend to submit to this court that there was no guidance on the conduct of remittal or retention. If I said that, I certainly didn't intend it. And indeed, I should just observe that over the lunch and adjournment, my solicitor was in the process of getting precisely this practice to the court, and I'm grateful to my own friend who achieved that more expeditiously than we did. When one looks at this practice statement, it does impact on the evaluation that this court has to perform of the conduct of the upper tribunal in this instance. Now, the appellant's case is that we were encouraged to believe, by the way that the error of law decision is framed, in particular the elements were concerned with rehearing, that there was going to be a very narrow evaluative exercise of specific issues of law and one specific issue of fact. I've invited the court to look at the skeleton argument which the appellant prepared in preparation.
Oh, no, we're going to look at the judgment to see whether or not you were entitled to come to that conclusion. Because at the end of the day, whatever your skeleton argument before the upper tribunal, the upper tribunal's determination, particularly in its final paragraphs, is going to dictate to us whether or not you were led, unfortunately, into a situation where you say you didn't put your full case or not.
No, I absolutely understand. And again, I think the impression was formed earlier that I was purposefully critical of the upper tribunal. If anything has happened, it's a misunderstanding. But that doesn't remove the fact that there are consequences.
Well, there may be, but it's whether or not the interpretation that you've placed upon it is a fair one. And we've spent some time on that, Mr. Jones.
And I'm not going to dwell on it, lady, save to say this, that it is clear from that skeleton argument how the appellant is approaching the reconsideration. That skeleton argument was before the upper tribunal in advance of the hearing. If the upper tribunal familiarised itself with that document and said, well, in fact, what you understand the purpose of this and the parameters of this reconsideration to be is incorrect, they should respectfully have put that, the appellant, to enable the appellant to reconsider the way that the case was going to be put to them.
Well, I hear what you say, but
So that's the first point,
Yes.
really. And then the second point, with regard to the practice statement. The learned friend took you to paragraph 7 and stepped over briefly paragraph 7.2. I take you back to that, if I may, and to subparagraph B. Because what is said in subparagraph B also plays in and substantiates the appellant's understanding of what was happening at that reconsideration process. It says at 7.2, the upper tribunal is likely on each such occasion to proceed to remake the decision instead of remitting the case to the First Tier Tribunal unless the upper tribunal is satisfied, B, the nature or extent of any judicial fact-finding which is necessary in order for the decision in the appeal to be remade is such with regard to the overriding objective of Rule 2 it's appropriate to remit the case to the First Tier Tribunal. Now,
So what's the overriding objective in Rule 2 that you say is brought into account?
the overriding, that is in the tribunal's rules itself, which is the just disposal of the appeal.
Yeah, so on that basis, the upper tribunal had to make that determination.
The determination, lady, the dictate is that if there's going to be extensive fact-finding, then the tribunal will actively have to consider whether or not to remit, because the purpose of that, the consequences of retaining are, for instance, the reduction of access to a second tier of appeal, in particular one which is not subject to the second appeals test, for instance. So it is a substantial disbenefit. And the appellant approaching the indications provided by the upper tribunal at the error of law stage by reference to what typically occurs in the context of remitting.
I don't think that's what paragraph 7.2 says, actually. It says, unless the upper tribunal is satisfied that the nature or extent of any judicial fact-finding which is necessary in order for the decision in the appeal to be remade as such. And quite clearly from the judgment that we're talking about now, the remaking judgment, it constantly refers to taking into account the findings of fact of the First Tier Tribunal.
But my lady, what it also does on our submission, which we've made consistently, is that it goes behind material parts
Well,
of
we've heard that. We've heard that. But
so it is.
That's not the point of 7.2b.
Well, the expectation generated by the terms of the error of law hearing disposal, by the directions.
Well, we know what you say the expectation was. We've heard that. Is there any point further that you wish to make on 7.2b?
It is also made encouraged by the terms of this practice statement, because
well, you didn't refer to this before it was brought before the court this afternoon. So if you were going to make this point, shouldn't it have been centre point of your skeleton argument?
Well, lady, I'm familiar with the statement, and before the upper tribunal, when engaging in the error of law hearing, I'm conversant with the terms of that statement.
But when I was asking you this morning, Mr. James, and I'm sorry to remind you, when I was asking you whether there was any guidance, you didn't refer us to this.
I'm not sure that I certainly didn't say there was no guidance, and I certainly didn't intend to mislead the court in any way. But from experience and practice, the way that the upper tribunal operates in the context of this practice statement is that in instances where there are not going to be comprehensive findings of fact necessary, it will retain a case. In instances where there are, it will remit a case.
Well, we will then come to a determination as to whether or not the upper tribunal actually did make extensive findings of fact in addition to those of the First Tier Tribunal.
Yeah, absolutely, my idea. Just one final observation, just to respond to a point I think that was brought up this morning with regard to directions from that tribunal at the error of law stage and thereafter.
Well, does this arise from the
it arises from
submissions
something,
of
lady, that you
Mr.
mentioned
Malik?
this morning. I just
So
wanted to
does it
clarify.
arise from Mr. Malik because you linked to his submission?
I was simply seeking to assist the court, that's all.
Well,
If I may.
we will be assisted, I've got no doubt, by Mr. Jones, by your response to the submissions made by
Very well.
Mr. Malik.
Just to say, there are no other directions save those which are specified in the error of law decision itself. I just wanted to be clear about that in case the court anticipated there was some other document.
But I didn't actually.
Well,
But let's get on with the response, shall we?
of course, ma'am. Lady, in the context of this step, this second step as well, my own friend took you to LS Uzbekistan and said, well, that decision is confined to the particular statutory system that was operating at that time. We say respectfully that is not the case. Principles that are described in that decision have continuing relevance. It may be that in the specific context of that case, the disposal is affected by that statutory scheme, but the principles are not, in particular the principle at paragraph 19 with which this court indicated it was familiar. And the court will be assisted in that respect by reference to two further decisions in the judgment, which I'll just give you the references for, and the court can turn them up itself in due course. The first is the case of Gazon, which appears in tab 18, page 428 of the authorities bundle in paragraph 28. And the second is the case of Lowe, with which I know this court may be familiar. The case of Lowe appears at tab 11, page 274, paragraph 28 and 29. And it probably is helpful very quickly to turn up Lowe and just refer to paragraph 29, where what you see is, again, this is page 274 of the authorities bundle. If you like, it is a reminder again of the importance of not interfering with findings of the tribunal below. And as the leadership has said, you will discern for yourself the extent to which that's been done. But I simply make the point that that guidance in Uzbekistan still holds force by reference to current authority. And lady, Lords, if we just go on to the third step, the third point, I'll just make a few brief observations about the issue of expert tribunals. In fact, it may suffice for me to just direct the court to my note at paragraph 76, page 14 of the speaking note. We obviously do not seek to go behind the principle expressed by Baroness Hale in A.H. Sudan. But we do encourage the court to consider the context in which the views expressed there were framed. And the same point could be taken with regard to Jones, and I have, to assist the court, sidelined all of the material aspects of Jones that would assist the court in understanding how it is that the court arrived at its conclusion with regard to the treatment of expert tribunal decisions. What one finds, predictably, is that the facts and the nature of the argument before the court influence the opinions that are being and findings that are being expressed. In A.H. Sudan, for instance, the issue there was the application of the internal relocation test, which the court, and I've given you the references, described as a very straightforward test, which had been clearly and coherently articulated in Januzzi just a few months before A.H. came out. And so what the court was basically saying is, when you're dealing with a tribunal that is concerned with these kinds of legal considerations and tests, where those tests are clearly articulated, you give a certain amount of scope for the evaluation that's performed. You give a little more, you assume the approach that they'll take and its consistency with that. And my own friend may have a point, for example, in that context, in the submissions we make with regard to the public implications and the evaluation of private life with regard to CI, because as you identified, CI was referenced in the course of the upper tribunal's determination. So the court may form the view that, reading into it, it has not directed itself in a way which is inconsistent with that decision, because it was familiar with it. I'll come back to that briefly in a moment. But generally speaking,
You're going to have to be very brief.
I will endeavour to be brief, lady. But
You're not going to endeavour, you are going to be brief, I'm afraid, because we're going to get to a stage where it's the end of the day, and any response will have to be made in writing, and I will be very specific at what extent of additional written materials we'll accept.
That won't be necessary, lady. If you can
Right.
bear with me for another 15 minutes, I will be...
No, not necessarily. Let's get on to the response, because you are rehearsing once again some of the arguments that you've made. We've got your points. We do need your response, and the response of Mr. Malik was very focused with respect.
Well, my lady, equally, with respect, I am
We
responding.
can argue between ourselves and take up more of your time if you
not
like,
going
Mr. Jones.
Lady,
But I do try and encourage you to get on with the response. You don't have to respond to everything, but there are certain points you will obviously want to respond to.
Moving on then, you have my position with regard to the expertise of the tribunal and the way that one approaches that.
We do.
It's context-driven, and you're also assisted by the other authorities of Lowe and Garzon that I've referred you to. We say the First Tier Tribunal was the expert tribunal here. The upper tribunal should have exercised more caution in interfering with its findings, and not, and this court should bear that in mind. With regard to the question of rehabilitation, I think my learned friend, in a sense, answered his own observation that there is no distinction between Bimbuga and HA by acknowledging that, in fact, the Secretary of State is contesting the disparity in approach in those two cases to the Supreme Court. There clearly is a distinction in the way that those two cases have approached the question of rehabilitation, and we, as I've already done, encourage the approach in HA. With regard to what rehabilitation means, we say simply, although the language of HA is that it may not make a difference in many cases, it can make a difference in some cases, and it should in this case. It's a fact-driven assessment. And on the question of offending, I don't need to repeat what we've said, but the Secretary of State, the upper tribunal has, we say, gone behind a legitimate and comprehensive assessment of rehabilitation and reoffending risk performed by the First Tier Tribunal, and without any good reason to do so. And I think the court may be assisted by looking at the case of AA, tab 13, paragraph 40, where this court identified that it was a permissible exercise for a First Tier Tribunal judge to perform, provided it was a coherent and thorough one, which in this instance it entirely was. On that point I just visited a moment ago about public interest and private life and the way that CI impacts on that, we say simply that familiarity with an authority is not the same as applying it properly. And the upper tribunal erred in its approach in this instance by going behind that which CI advocated, which is not to factor in to the weight that one gives to private life, the fact of offending, or indeed the perception that their reprehensible conduct in and of itself impairs the quality of private life. It does not. And then finally, with regard to HA Iraq and the approach to the unduly harsh assessment, I completely acknowledge that what was being said in the court was with regard to the satisfaction of a test by reference to exception 117C5, which is met in this case. But that does not mean that the guidance in that decision cannot assist in evaluating whether or not that threshold is surpassed marginally or substantially. And in this instance, the guidance I've directed the court to enables a judgment that when one accumulates the many factors that identify undue harshness, you have a case here both in respect of the appellant's partner and his child that go well beyond that boundary, and the decision of the upper tribunal was preferred. Those are our submissions.
Very much.
Just one point, thank you, Mr. Jones. Right at the beginning, you accepted that the summary by the upper tribunal of the law in paragraph 18 of its second judgment was correct. Can I invite your attention to paragraphs 5 and 7 of that very succinct summary, where it's made clear that 117C6 requires wide-ranging exercise to be carried out to ensure that Part 5A produces a result compatible with Article 8. And it then, in subparagraph 7, goes on to explain that the wide-ranging exercise means that a serious offender is permitted to rely on matters in one or both of the exceptions, as well as his ability to meet these in conjunction with other factors collectively when assessing 117C6, CNA Pakistan, although the exceptions are self-contained and exclude further consideration of the public interest, CKO, in order to determine whether the public interest is defeated by, quotes, very compelling circumstances, a case-specific analysis of the public interest is necessary, CMS. So it's clear from that summary, succinct summary of the law, that a wide-ranging exercise is required to be carried out, a wide-ranging evaluative exercise. how does that sit with your response to Mr. Malik and your case that the upper tribunal were not entitled to conduct anything other than a narrow exercise?
Well, because this is a position that's articulated in a determination that's promulgated after the reconsideration hearing. In terms of this is not the position, in the procedural context, it's not the position that was understood by the appellant. And in terms of...
It's a legitimate expectation point that you're essentially making in this case, although you haven't, in a sense, gone through the principles that would be required to make a legitimate expectation case succeed.
I suppose one could put it in that way, my lord, but it's equally a question of basic fairness. An individual understanding what the case is that they have to meet. And in terms of the broader issue, my lord, I have no difficulty with what's said in the paragraphs to which your lordship has referred. Yes, the upper tribunal had to arrive at a final decision with regard to whether or not that very compelling circumstances were made out. But on our case, it should have done so exclusively by reference to the first tier's findings. Save that, it had to correct and evaluate for itself whether there were particularly strong features of a private life, and it had to weigh the impact of recognition that the Maslow principle was in operation. That it had to do. Apart from that, we understood, and it should not have gone any further. That is our case in respect of that part of the submission. So there's nothing wrong with what's said, it's what's done that is the issue.
Thank you.
Yes, of course you can.
You said a number of times, Mr. Jones, in relation to the provision that in all cases consideration must be given to section 117B, that is in some way undermined by KO. I've been just looking at KO, and I can't see how one gets that from KO.
Lord, well, let me just get my speaking note if I may. I think we looked at, yes, it's paragraph 16 of the speaking note. So I think it was paragraph, KO is at tab 5.
Yes.
And I think it's paragraph 20 to 22 that I was relying upon for that proposition.
Well, they say that the Supreme Court says that, I think the point that we've already touched upon, that 117C4 doesn't involve a balancing exercise. And 5 doesn't involve the other side of the coin, as it were. But I don't see where you get from that the injunction to consider the considerations in 117B is in some way disapplied.
I think it's primarily from paragraph 21, and the third sentence, exception 1, seems to leave no room for further balancing. It's precisely defined by reference to 3 factual issues: lawful residence in the UK, social and cultural integration into the UK, and very significant obstacles to integration. So if that is precisely, and then the consequence of inclusion within that is that you are not deportable. So that is where we get it from, which is that you do not then, having identified inclusion as a medium offender within that exception and qualifying it, go back to 117B5 and say, well, nevertheless, your status was precarious because you didn't have settlement.
No, perhaps I think misunderstands the nature of what 117B5 is about, which is when you are conducting a balancing exercise, what weight do you give? If you're not conducting a balancing exercise, then that question doesn't arise.
I'm not sure I follow the I'm not sure
Well, I think
how...
the important point is that when one comes to 117C6, the question of very compelling circumstances, is one required to take into account, pursuant to 117A, the factors, namely little weight should be given? As I understand it, you're trying to pray in a KO to say that KO would lead one to believe that one doesn't take into account 117B5 when considering 1176.
Oh, no, Lord, no, I'm not saying that. I apologise. What I'm saying is that what the court in KO did was acknowledging those who are eligible within the exception, medium offenders, that there is no further balancing exercise,
Yes.
and so it doesn't apply in that context. And I'm seeking to extrapolate from that it would be logical and consistent with the structure of the statutory system to extend that comparable benefit to a very compelling circumstance case. I'm not suggesting that KO says that you can't use it in 117 C6 cases at all. I wish it did, because it would make my life a lot easier, but that's not what it said.
KO wasn't a 117C6
It was not,
case, was it? It's simply a law. So,
exactly,
my lord,
right? I'm seeking to obtain benefit from indications furnished elsewhere as to how the statutory scheme operates, and encourage a particular interpretation of the scheme by reference to those indications.
But there was actually nothing, sorry, forgive me, but there was nothing in KO to suggest that the Supreme Court was suggesting that the wording of 117A2A did not mean what it said.
No, but what there is in KO is a discounting of 117B5 on the basis the exception is met. And so, by implication...
My Lord's invited you to take us to the part of
Well,
KO that says that. That's your interpretation, but my Lord finds difficulty in seeing it. And I must say, speaking for myself, I agree with it.
So do I, because it simply doesn't. The Supreme Court were not considering 117C6 at all. This was purely in the context of what Mr. Malik says, the threshold exercise that you get for exceptions 1 and 2.
Whatever else comes out of this appeal, what I don't want to do is to take us back to a position where, to interfere with a settled position in law. Our case is that in 117B4 instances where the exception is satisfied for medium offenders, the approach now, pursuant to KO, is that one does not seek to incorporate then a separate evaluative exercise of public interest considerations by reference to the provisions in 117B.
Yes.
That is all I can take from KO.
In no way does the Supreme Court suggest that is a derogation from 117A2A.
No, but the point, that is the only point I sought to make, was that an exception has been recognised in the context of those who actually qualify within the 117C4 exception, that you do not factor in. And I simply sought to draw from that there would be a logical and rational reason to extend that benefit on for those in the serious category who also qualify within the terms of the exception but do not benefit from it because they're serious offenders.
Thank you very much.
Thank you. Well, we will obviously reserve our decision. We will send out a draft in the fullness of time in order that those who sit behind you, particularly Mr. Jones, understand we will not entertain any further arguments. The purpose of sending out the draft is merely for identification of any typographical errors. And once the draft has come through, we would hope that any consequent orders can be agreed, and we will require a draft order to be submitted, whichever way the judgment indicates.
Of course.
All right.
And may I just say to the court, I'm grateful for your patience today. I appreciate it.
Somewhat
No,
more.
we can tell the great and conscientious industry that has been put into the arguments that we've heard, Mr. Jones, and as I say, we've been attempting to clarify for ourselves points by our questioning of you.
It's been helpful. I'm grateful.
Thank you both very much indeed. Oh, and of course, thank you to Miss Simak and all of your instructing solicitors. I know, Mr. Malik, that yours is watching this on streamed
Yes, lady, they are.
basis, and I understand the reason why. And I know, Mr. Jones, that you've been assisted, obviously. So thank you
I would have
for those also.
All right.